Hello everyone, welcome to MAYANK LAWHOLIC. This video is in continuation of DJS HJS solved paper of 2019. Here we will continue to solve from question number 54. A decision rendered in a proceeding again under section 372 Indian Succession Act 1925 option 1 is a summary in nature. Option 2 does not finally decide the rights of the parties. Option 3 does not bar the trial of the same question in any other proceedings between the same parties. And option 4 all of the above. Here the correct answer is option 4 all of the above. Section 372 of Indian Succession Act 1925 talks about application for certificate. Now we will see the question number 55. Question number 55 is X would be said to have died intestate in the following situations. 1. X who left a will whereby he has appointed Y his executor, but the will contains no other provision. Option 2. X has bequeathed his whole property for an illegal purpose. Option 3. X has bequeathed 1000 rupees to Y and 1000 rupees to the eldest son of Z and has made no other bequest and has died leaving the sum of 2000 rupees and no other property. Z died before X without having ever had a son. X died intestate in respect of the distribution of 1000 rupees. And option 4 all of the above. In question number 55 the correct answer is all of the above. Mr. Sharma dies intestate. He leaves behind his wife, a son and a daughter. In order to be able to administer and manage the movable and immovable property left by him, the son can file A. a probate petition, B. petition for a letter of administration, 3. an application for succession certificate, 4. petition under section 92 CPC. The correct answer is petition for a letter of administration. When a person dies intestate or doesn't nominate an execution under the will, it is the letter of administration acts as a facilitating document. Letter of administration is granted to the beneficiaries after they apply to a court of law having competent jurisdiction. One more thing, letter of administration entitles administrator to all the rights belonging to the intestate as effectually as if the administrator had been granted at the moment after his death. Now we will move to question number 57. A grant of probate of a will. Option 1 constitutes the grantee, the sole heir of the deceased and the owner of estate bequeath. Constitutes the grantee the sole heir of the deceased but not the owner of the estate bequeath. Option 3 only declares the documents to be validly executed last will of the deceased. Option 4 only interprets the documents claimed to be the will of the deceased. Here a grant of probate of will, option 3 is the right answer, only declares the documents to be validly executed last will of the deceased. Now question number 58. The deceased L, a Hindu, married again during the subsistence of the first marriage. The first marriage was legal. The second wife bore him a daughter M. The court found the marriage to the second wife was not valid under the Hindu Marriage Act. What is the nature of M qua the state of L? Here the correct answer is, now let us first see the options. M shall be entitled to only become a coparsoner in the coparsonary of which L was a member and to claim petition thereof. M can inherit L's asset as an illegitimate child. Depends upon the discretion of the court. M will not inherit any part of the estate of the deceased. Here the correct answer will be the answer second. M can inherit L's estate as an illegitimate child because their marriage was not the valid marriage. So the option second is the correct answer. Now let's see the question number 59. The self-acquired property of a Hindu married female dying intestate whose husband predeceases her and who did not have any children devolves upon the following. Options are on her parental heirs, second on her husband heirs, third on her maternal heirs, and fourth depend upon the discretion of the court. In this question, correct answer is on her husband heirs. Question number 60. Inherited property of a Hindu widow who dies intestate and had a son and daughter shall devolve upon son and daughter depends on the discretion of the court. Here the correct answer is son and daughter. Question number 61. The Hindu Succession Act 1956 applies to the person of all the following religion. Hindu, Sikhs and Parsis. Second option Hindu, Jains, Buddhists and Sikhs. Third option only Hindus. And fourth option Hindu, Jains, Buddhists, Sikhs and Jews. In question number 61 correct answer is Hindu, Jain, Buddhist and Sikhs. The Hindu Succession Act does not apply to Jews. That's why this is not the right answer. And here on Parsis also Hindu Succession Act does not apply, so this is also not the right answer, but it applies to Hindus, Jains, Buddhists and Sikhs. So the correct answer is option 2 Hindus, Jains, Buddhists and Sikh. Which of the following statement is true? Statement 1. A general authority to transact business and to receive and discharge debts is sufficient to empower the agent to bind a principal by endorsing bills of exchange. Option 2. A minor may draw, endorse, deliver, and negotiate notes, bills, and checks so as to bind all the parties except himself. Option 3. When a day on which a promissory note or a bill of exchange is at maturity is a public holiday, the instrument shall be deemed to be due on the next succeeding business day. Option 3. An instrument which may be construed either as a promissory note or a bill of exchange is called a inchoate instrument and is invalid. In all the statements, the statement 2 is the correct statement. A minor may draw, endorse, deliver, and negotiate notes, bills of exchange so as to bind all the parties except himself. Let us see the question number 64. When a contract creating partnership is rescinded on the ground of fraud or misrepresentation of any of the parties thereto, the party entitled to rescind his inter alia entitled in law to a lien over the entire assets of the firm forthwith towards any capital contributed by him. Option 2. A right to be indemnified by the partners guilty of the fraud against all the debts of the firm. Option 3. Premium for his share. The option 4. The goodwill of the firm preferentially. Correct answer is option 2. A right to be indemnified by the partners guilty of a fraud against all the debts of the firm. Now let us see the question number 65. Which of the following rules shall be observed in settling the accounts of a partnership firm after dissolution, subject to the agreement by the partners? Losses including deficiencies of capital shall be paid first out of profits, next out of capital, and lastly it is necessary by the partners individually in the proportion in which they were entitled to share profits. Option B. The assets of the firm, including any sums contributed by the partners to make up deficiencies of capital, shall be utilized in paying the debts of the firm to the third parties. Option C. The assets of the firm, including any sums contributed by the partners to make up deficiencies of capital, shall be applied in paying to each partner ratably which is due to him from the firm of advances as distinguished from the capital. Option D. The assets of the firm, including any sums contributed by the partners to make up deficiencies of capital, shall be applied in paying to each partner ratably which is due to him on the account of capital. Options are A and B above, A and C above, A and D above. Option 4, all of the above. So option 4 is the correct answer because all these statements are the correct statement. Now let us see the question number 66. A person who is a minor can be admitted to the benefits of a partnership if his share is liable for the acts of the firm. He can elect on attaining majority to continue as a partner by issuing public notice. He can be made personally liable. He may not sue the partners for the payment of his shares save when serving his connections with the firm. Which of the following is the correct answer? Here in this question the answer 3rd is correct, 1st, 2nd and 4th. Option 3 is not correct. He cannot be made personally liable. Here it is written he can be made personally liable. Okay, now let us see the question number 67. When any borrower defaults in the repayment of the secured debt or any installment thereof, the secured creditor may, within the meaning of section 2 of the Securitization and Reconstruction of the Financial Assets and Enforcement of Security Interest Act 2002. Option 1. Without notice to the borrower to discharge his full liability, taking possession of the secured assets within 30 days of the default by filing application before the Chief Metropolitan Magistrate or District Magistrate, after requiring the borrower to discharge full liability, obtain order of attachment before judgment to the secured assets from DRT. Option 3. Issue a notice to the borrower calling upon him to discharge full liabilities within 60 days, considering the representation or objections, if any, raised by the borrower. Communicate reasons to the borrower, taking possession of the secured assets of the borrower, take over the management of the business of the borrower. And option 4. Immediately take over the management of the business of the borrower for the realize the secured debt. In this question, the correct answer is option 3. When any borrower defaults the repayment of a secured debt or installment thereof, the secured creditor may, within the meaning of section 2 of the Securitization, Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, issue a notice to a borrower calling upon him to discharge full liabilities within 60 days, considering the representation of objections, if any, raised by the borrower. Communicate reasons to the borrower and taking possession of the secured assets of the borrower and take over the management of the business of the borrower. So the option 3rd is the right answer. Now let us see the question number 68. The secured creditor may, option 1, before exercising his options under Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, seek recovery from guarantors, file an application to the DRT or a competent court for the recovery of the balance amount of the secured debt not fully satisfied by the sale of the secured assets. Which of the above statement is correct? Options are both the above, none of the above, only one, and only second. Here the correct answer in this question is both the above. Both the options relating to secured creditor are correct in this question. Now let us see the question number 69. In the light of section 6 of the Specific Relief Act 1963, which of the following statement is true? Statement first, any person who is dispossessed without his consent of immovable property otherwise other than in due course of law may by suit instituted within 6 months from the date of dispossession recover possession thereof. Option second, no suit under this section shall be brought against the government. Here the options are only one is correct, only second is correct, neither of them is correct, and both first and second are correct. In question number 69, the correct answer is option 4. Both first and second are correct. Section 6 of the Specific Relief Act talks about suit by a person dispossessed of immovable property. And both the options are correct here. Now let us see the question number 70. A entered into a contract with B regarding the construction of a classroom at IHI Institute, Hyderabad. According to the agreement, the contract was to be completed within 9 months of the contract. However, B could not complete the contract within the stipulated time and demanded an extension of another 9 months. Finally, the extension was granted and the contract was completed after 18 months. A clause in this contract provided that in case of any failure or delay in the completion of the contract, the said failure or delay shall not vitiate the contract nor entitle the contractor to damages or compensation thereof. It was agreed that only a reasonable extension may be granted for the completion of the contract. A dispute arose between the parties which was referred to arbitration, wherein B demanded compensation or damages. In the light of the above mentioned facts, which of the following is true? So options are the contractor is entitled to damage or compensation. The contractor shall not be entitled to damages compensation. The contractor shall not be entitled to damages or compensation because the contract only provides for reasonable extension time and no compensation in case of any delay or failure in the completion of the contract. The contractor shall not be entitled to damages compensation because the right to damages cannot be restricted despite absence of a clause for a monetary relief in the contract. So in this question, the statements 1 and 2 are not to be considered. Option 3 and 4 are elaborately discussed, but option 4 should not be considered in this question because it does not specify the correct answer. Option 3 is the correct answer because it was written in the contract that of the reasonable delay. So the third statement, the contractor shall not be entitled to damages compensation because the contract only provides for a reasonable extension of time and no compensation in case of any delay or failure in the completion of the contract. So this is the right answer. Now let us see the question number 71. Ravi, a trader at Chennai, by letter directs T to sell him some goods lying in a warehouse in Mumbai, and afterwards by letter revokes his authority to sell and directs T to send the goods to him Chennai. After receiving the second letter, enters into a contract with S, who already had information about the first letter sent by R, but not of the second letter for the sale of goods to him. S pays T the money, with which T runs away. In the light of the above facts, which of the following statement is correct? Option 1, H payment is not good as against R. Option 2, H payment is good as against R. Option 3, R can recover payments jointly and severally from S and T. And option 4, none of the above. In question number 71, the correct answer is option 2. As payment is good as against R. Now let us see the question number 72. A entered into a contract to purchase tomatoes from B, which were to be sourced by B from a farm of C. However, due to heavy floods, there was no crop of tomatoes on the farm of C. Here, the options are A may sue B for damages, A or B may treat that agreement is void, neither A nor B is at fault. A may sue B for delivery, only B can treat the agreement as void. From the above statement of question, it is correct. The correct answer will be second answer because it will not be possible for them to perform the contract, so it becomes a void. A or B may treat the agreement as void as neither A or B is at fault. Which of the following statement is incorrect? In this question, an incorrect statement is asked. Stipulation as to time of payment is not deemed to be the essence of the contract of sale under Sales of Goods Act 1930 unless otherwise specified. Option 2, the warranty is a stipulation collateral to the main purpose. Option 3, warranty is accompanied with the right to reject the goods but without right to claim damages. In this question, the correct answer is only third. Warranty is accompanied with the right to reject the goods but without right to claim damages, because in this question is incorrect statement is asked. So this is the incorrect statement. Other statements are correct statement. Statement first and second. Now let us see the question number 74. A agrees to supply B sunflowers for extraction of oil at a future date at a price not fixed as per the current market. Can he do so? Options are yes, section 6 recognizes the agreement affecting the present sale of future goods. No, agreement is void under section 30 of the Indian Contract Act 1872 as it is a wagering contract. Option 3, no, as the price is not fixed under section 9 of the Sale of Goods Act 1930. Option 4, since there are no goods, the contract is voidable under section 17 Sales of Goods Act 1930. The correct answer for this question is yes, section 6 recognizes the agreement affecting the present sale of future goods. Section 6 of the Sales of Goods Act 1930 talks about the existing or future good. Section 6 clause 1, the goods which from the subject of a contract of sale may be either existing goods owned or possessed by the seller or future goods. So the correct answer is option 1. Now let us see the question number 75. An exporter in India X entered into an agreement with an importer in Germany Y and agreed to deliver 500 tons of basmati rice. The delivery was to be at the Hamburg airport in Germany, though Z shipping company with the first port of a call being port at Genoa. The shipment has to be delivered within 40 days of the opening of the letters of credit. The seller shipped the goods 16 days later than the stipulated time. Hence, he could not ship the merchandise through Z shipping company. He loaded the same on the ship of ZL company, which was not passing by the designated port of Genoa. On the way, the ship developed a snag. As a result, the ship was taken to Turkey, where the repairs were carried out, after which the goods reached the port at the Hamburg 40 days later. When the goods were to be taken on delivery, it was found that due to rise in humidity levels, the good had putrefied. In the light of these facts, which of the statement are correct? Statements are the buyer will have to suffer the damages as the bill of lading have been handed over. Option second, the seller have to take the risk and be liable for the pay damages as under section 26 until delivery. The risk remains to the seller. And option 3, the contract is voidable at the instance of the seller under section 7 as the goods has perished because of the ship and had developed a snag. The seller is not liable to pay damages. The buyer can claim insurance. In this question, the correct statement is statement second, because here it is required to understand the section 26 of the Sales of Goods Act. Sales of Goods Act in section 26 talks about the risk prima facie passes with the property. It says that unless otherwise agreed, the goods remain at the seller's risk. The goods remains at the seller risk until the property therein is transferred to the buyer. But when the property therein is transferred to the buyer, the goods are at the buyer's risk, whether delivery has been made or not. So here the delivery has not been made, so it is at the risk of the seller to with related to section 26. So this is the correct answer. Question number 76. While sentencing the accused in an offence under Prevention of Corruption Act 1988, the relevant criteria is reformation, deterrence and denunciation, both 1 and 2, and none of the above. Question number 76, the correct answer is option 2, deterrence and denunciation. Now let us see the question number 77. A special judge is trying a case for the offence of Prevention of Corruption Act 1988 as well as Non-Prevention of Corruption Act 1988. The sole public servant dies after a special judge has exercised his power under section 4 clause 3 of the Prevention of Corruption Act 1988. The options are the proceeding before the special judge vitiate, the special judge is divested of his power, the proceeding before the special judge which continue, and option 4, both 1 and 2. Here the correct answer is the proceeding before the special judge will continue. Now let us see the question number 78. Previous sanctions is necessary for taking cognizance of the offences punishable under which of the following sections of the Prevention of Corruption Act 1988. Options are section 7 and 11, section 13 and 15, section 8 and 9, and both 1 and 2. Here the correct answer is both 1 and 2, that is section 7 and 11 and section 13 and 15. That means section 7 and 11 and also section 13 and 15. Section 11, 13 and 15 comes under the chapter 3rd of the Prevention of Corruption Act 1988, and these are related to offences and penalties. Now let us see the question number 79. Presumption under section 20 of the Prevention of Corruption Act 1988 is applicable for offences punishable under which of the following sections of the Act? Options are section 7 or 11. Option 2, section 7, 11 or 13. Option 3, section 7, 8, 11 or 13. And option 4, all the offences under the Prevention of Corruption Act 1988. Here the correct answer is option 1, section 7 or 11. Section 20 talks about the presumption where public servant accepts gratification other than legal remuneration. Which of the following is a public servant within the meaning of the Prevention of Corruption Act 1988? Option 1, chairman of a private bank receiving financial aid from central government. Option 2, arbitrator appointed by a public authority. Question 3, a commissioner appointed by courts. And option 4, all of the above. In this question, all of them are the public servant with relation to the Prevention of Corruption Act 1988. In IPC section 21, public servant is defined. Now let us see the question number 81. Which of the following sections under the Protection of Children from Sexual Offences Act 2012 POSCO provides that if an act of the offender constitutes an offence of rape under IPC as well as under the Protection of Children from Sexual Offences Act 2002, then he is liable for punishment in either the Protection of Children from Sexual Offences Act 2012 or IPC, whichever is higher. The options are section 42A, section 10, section 8 or section 42. Here the correct answer is section 42. POSCO Act 2012 section 42 talks about the alternate punishment. Presumption of culpable mental state on the part of the accused is provided under which of the following offences of Protection of Children from Sexual Offences Act 2012? Option 1, offences punishable under section 4 and 6 only. Option 2, offences punishable under section 14 and 15 only. And option 3, offences punishable under section 8 and 10 only. Or all of the above. In this question, the correct answer is all of the above. Section 4 talks about penetrative sexual assault, and section 6 talks about the punishment for aggravated penetrative sexual assault, whereas section 8 talk about the punishment for sexual assault, and section 10 talks about the punishment for aggravated sexual assault. And here similarly, section 14 and 15. Section 14 talks about punishment for using child for pornographic purposes, and section 15 talks about punishment for storage of pornographic materials involving child. Here the option 4 is the correct options, all of the above. Question number 83. A makes a child aged 10 years to touch the penis of other person. Option 1, A is guilty of only sexual assault. Option 2, A is guilty of only penetrative sexual assault. Option 3, A is guilty of aggravated sexual assault. And option 4, all of the above. Here the correct answer is option 3, A is guilty of aggravated sexual assault, and aggravated sexual assault is given under section 7. Now let us see the question number 84. While recording the statement of a child under section 164 of CRPC with regard to an offence under Protection of Children from Sexual Offences Act 2012. Option 1, the presence of the advocate of the accused is mandatory. The presence of the investigation officer is mandatory. The presence of a parent of a child or such other person whom the child trusts is mandatory. 4, all of the above. Here the correct answer is option 3. The presence of the parent of the child or such officer in whom the child has trust is mandatory. Question number 85. Non-explanation of injuries on the person of the accused by the prosecution witness. Option 1 is always fatal to the prosecution case, is never fatal to the prosecution, may affect the prosecution case, provided serious injuries are suffered in the same occurrences. And option 4, none of the above. Here the correct answer is option 3, may affect the prosecution case provided some injuries are suffered in same occurrences. 86. For an offence punishable under section 498A of IPC. Option 1, court where the offence was partially committed will have jurisdiction. Court where the matrimonial home is situated will have jurisdiction. Court where wife has taken shelter will also have jurisdiction. And option 4, all of the above. Here the correct answer is all of the above. Section 498A of IPC talks about whoever being a husband or the relative of the husband of a woman subjects such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. So this section 498 talks about the cruelty. Section 303 of Indian Penal Code was struck down by the Supreme Court in which of the following judgments? Options are Gayatri versus State of UP, option 2 Mithu versus State of Punjab, option D Virsa Singh versus State of Punjab, and Raghunath versus State of Haryana. Here the correct answer is Mithu versus State of Punjab. By this case, the section 303 of IPC was struck down by the Supreme Court. Section 303 of IPC talks about the punishment for murder by life convict. Question number 88. A is married and is having one child. A is husband and B does not live with her. C on false promise to marry A makes physical relationship with her and later refused to marry. Options are C has committed the offence of rape. Option second, C has not committed the offence of rape. C has committed the offence of sexual assault. And option 4, C has committed the offence under section 494 of IPC. Here the correct answer is option second, C has not committed the offence of rape. Question number 89. Any omission or error in framing of charge, either stating the offence or particulars required to be stated therein, is fatal to be trial, is always material, is material only if occasions in failures of justice cannot be altered during the trial. Here the correct answer is material only if occasions in failure of justice. Now let us see the question number 90. The Government of India in 1992 has acceded the Convention on the Rights of the Child was adopted by the option 1 Parliament, option 2 European Council, option 3 General Assembly of United Nations and option 4 Security Council of United Nations. Here the correct answer is option 3 General Assembly of United Nations. This convention of 1992 was signed in 1992 and in later 2012 POSCO Act was created related to this convention. On 14 November 2012 POSCO Act enforced. Now let us see the question number 91. A child in need of care and protection within the meaning of Juvenile Justice Care and Protection of Children Act 2015 means a child who is found begging, who is found working in a contravention of labor laws for the time being in force, who is without any home. Option 4 all of the above. In this question all the options which are given are correct because the option 4 which says all of the above is the right answer. Now let us see the question number 92. Which one of the following statement is correct? Undue advantage under section 2D of the Prevention of Corruption Act 1988 is legal remuneration only. Gratification under the Prevention of Corruption Act 1988 means pecuniary remuneration only. Option 3 legal remuneration is restricted only to remuneration paid to the public servant, and option 4 none of the above. In this question the correct statement is asked. None of the statements given are the correct answer, so the option is option 4 none of the above. Now let us see the question number 93. Sanction under the section 19 of the Prevention of Corruption Act 1988 is a mere formality to protect a public servant against malified prosecution. Option 3 exactly similar to section 197 of the Code of Criminal Procedure 1973. Option 4 only required if public servant has retired. In question number 93 the correct answer is option 2 to protect a public servant against malified prosecution. Now let us see the question number 94. A public servant has a property disproportionate to his known source of income within the meaning of the Prevention of Corruption Act 1988 when he has more amount lying in his bank account than his monthly salary, has more than 5 immovable properties, fails to satisfactorily account for property, has more than 10 vehicles. In question number 94, the correct answer is option 3, fails to satisfactorily account for the property. Now let us see the question number 95. Gratification within the meaning of the Prevention of Corruption Act 1988 means pecuniary gratification, anything estimable in money, acceptance of anything to the pleasure or satisfaction of the recipient, and option 4, all of the above. All of the above statements are correct because all the three statements defines what gratification actually is. So all of the statements are correct. Now let us see the question number 96. Commercial organization under section 9 of the Prevention of Corruption Act 1988 does not include domestic companies, foreign companies, charitable or business organizations, subsidiary companies. Does not include section 9 of the Prevention of Corruption Act. The correct answer is 3, charitable or non-business organization. This is the correct answer because this asks which commercial organization does not include what. So commercial organization does not include charitable or non-business organization. And what does it include? This include domestic companies, foreign companies and subsidiary companies. Now let us see the question number 97. The Protection of Children from Sexual Offences Act 2012 was amended. Derives power from which of the provisions of the Constitution? The correct answer is Article 15 Clause 3, which state can make law for the protection of the children. I have made the entire video of POSCO Act. In the playlist you can find this, in which I have thoroughly discussed each and every section of the POSCO Act. Now let us see the question number 98. The Protection of Children from Sexual Offences Act 2012 is applicable when the victim is a child below the age of, options are 18 years, option 2 19 years and option 3 21 years and option 4 none of the above. POSCO Act applies to child irrespective of whether a boy or a girl below the 18 years of age. So this 18 years age option 1 is the correct answer. Question number 99. The Protection of Children from Sexual Offences Act 2002 provides protection from sexual abuse. I have already discussed this in question number 98. It is a gender neutral. POSCO Act is a gender neutral. So the option 3 will be the correct answer. It applies to both boys and a girl for the protection of sexual abuse. Now let us see the question number 100. Punishment for commission of offence of sexual assault, section 8 of the Protection of Children from Sexual Offences Act 2012 is not less than. Options are 3 years but may be extended to 5 years. Option 2 5 years but may be extended to 7 years and fine. And option 3 7 years but may extend to 10 years and fine. And option 4 10 years but may extend to 12 years and fine. Here the correct answer is option 1 3 years but may extend to 5 years and fine in section 8 of POSCO Act. The child friendly procedure under the POSCO Act 2012 is applicable only during investigation of an offence under the Act, only during recording of evidence for an offence under the Act, only during inquiring into an offence under the Act, and all of the above. The child-friendly behavior has to be applied everywhere during the investigation, recording of evidence, and also in inquiring. So the option 4 is the correct answer. Now let us see the question number 102. If the management or employer, after retrenching a daily wager, regularizes another serving daily wager, the employer's action would be violative of which of the following provisions? Options are Section 2E of the Industrial Disputes Act 1947, Section 25F of the Industrial Disputes Act 1947, Option 3, Section 25H of the Industrial Dispute Act 1947, and Option 4, none of the above. Here the answer is none of the above. All the sections which are given are not correct. So the answer is none of the above. Under the Payment of Wages Act 1936, in a factory or establishment wherein more than 1000 employees are working, the monthly wages must be released on or before the 5th day of the next month. Option second, the 7th day of the next month. Option third, the 10th day of the next month. And option 4, the 15th day of the next month. Here the correct answer is option 3, the 10th day of the next month. So we have already discussed paper part 2 completely. In the part 3, we will discuss the remaining questions. And recently I have made a Telegram group of this channel. Please subscribe to that also. Link is provided in the description section. Thank you for watching the entire video. Please give us a thumbs up. And thank you for supporting. Thank you for watching.